In the past 24 hours, the US Supreme Court has issued a major ruling on President Trump's Liberation Day tariffs. Markets, companies trading internationally, and legal commentators have been waiting months for this decision. The legality of the president's use of emergency powers to impose sweeping global tariffs has been hanging over supply chains, pricing models, and investment decisions since the measures were introduced last year. Now we have clarity, at least on one front. The court held that the president could not use the International Emergency Economic Powers Act, IEEPA, to impose tariffs on nearly every country in the world. IEEPA allows the president to act in response to a declared national emergency, and the court found that Congress did not authorize its use as a broad tariff mechanism. That narrows how emergency economic powers can be applied in trade policy, which I personally believe is appropriate. Before the ruling, the effective average US tariff rate was sitting at about 16.9%. According to analysis from the Yale Budget Lab, removing the IEEPA tariffs would have reduced that rate to around 9.1%, still historically elevated, but much lower. Small business groups welcomed the ruling, and economists described it as a significant moment for legal clarity. Markets moved higher in the news as well, and there was a brief expectation that tariff pressure might ease. But within hours, that expectation shifted. President Trump announced a new 10% global tariff, this time under Section 122 of the Trade Act of 1974. Section 122 allows the president to impose tariffs of up to 15% for up to 150 days in response to a large and serious balance of payments deficit. It's temporary unless Congress votes to extend it. So in practical terms, the court has closed off one legal pathway. It hasn't removed tariff authority altogether. And that distinction matters for anyone trading into or out of the United States. Now, there are also immediate operational questions emerging. What happens to tariffs already collected under IEEPA? Will refunds be issued? Will there be further legal challenges to the use of Section 122? And will Congress allow temporary measures to lapse or extend them? Now, for exporters, including Australian businesses selling into the US market, this is not just a Washington story. It affects landed cost calculations, pricing strategy, contracts, inventory planning, and currency exposure. The ruling demonstrates that institutional checks are still functioning. At the same time, it signals that tariff policy is likely to continue, but through different statutory mechanisms. For internationally scaling businesses, that means that the environment remains active and legally dynamic. The structure has changed. The trade friction has not disappeared, though. In the next episode, I'm going to walk you through the specific tariff authorities that remain available, including Section 122, Section 232, Section 301, and Section 338, and where in certain sectors tariff tools might be considered appropriate, because understanding the architecture of how trade power is now essential for anyone operating across borders.